So welcome to the sixth session of the 2020 McGill Tax Policy Colloquium. My name is Tarcísio Magalhães. I'm a tax lecturer at McGill Law, and I'm also a research professor of digitalization and taxation at the University of Antwerp. So let me introduce our very special guest. Today we have Professor Dr. Leyla Ates, who's currently the Dean of Altinbas University Faculty of Law in Istanbul, Turkey.
I would like to thank Tarcísio and Alison for inviting me and giving a chance to address these bright minds of McGill Law School and others. I have been conducted a project titled COVID-19 Turkish Tax Policy, Orientations and Legal Priorities. And today I will share some of its findings with you. First, I will give a brief overview of the current situation of the Turkish economy and short-term COVID-19 measures. Then I will focus on tax policy reform options after the COVID-19 crisis, especially to enhance international tax enforcement efforts. Just like many other countries, Turkey's economy has been significantly affected by the COVID-19 pandemic. The economy has downsized 9.9% in the second quarter. The International Monetary Fund's growth projection for Turkey is minus 5% for 2020, whereas the Organization of Economic Cooperation and Development's growth projection for Turkey is minus 2.9%. The Turkish government projected 0.3% growth in its medium-term program that was announced on September 29, 2020. This is well above the expectations considering the IMF and OECD's projections. The tourism sector, which is one of the most affected sectors from pandemic, is an important source of revenue for Turkey, downsized 78%. While our exports reduced by 30.7%, there is no parallel reduction in imports. The reduction in imports was only 3.9%. This situation increases our foreign trade deficits. Moreover, these difficulties occurred in a time where Turkey's economy had already been struggling. Most emerging market currencies recovered between April and June after the severe pressure during the market turmoil in March. However, because of its vulnerable fiscal position, the Turkish lira has weakened together with only a few other currencies of countries such as Russia, Argentina, and Brazil. While many countries are experiencing an economic recession together with near to zero low inflation, a high inflation accompanies recession in Turkey. This phenomenon is called slumflation in the economic literature. The Turkish government has adopted a broad approach from the very beginning of the process, using a combination of the short-term economic and financial measures against the COVID-19 pandemic. These measures include those that have permanent effects on the budget, such as short-time work allowance and other wage supports, as well as measures that have temporary effects on the budget, such as extended the tax declaration and payment periods. When the ratio of the total cost of these measures to the gross domestic products or GDP is taken into account, Turkey is at the top among the group of 20 or G20 countries, as you can see in the figure, taken from the June 2020. As of early September, the authorities estimate that the entire discretionary fiscal support package will amount to 573.7 billion Turkish lira, i.e. 12.8% of GDP in 2020. Of these, around 123 billion Turkish lira, i.e. 2.7% of GDP, is in the form of on-budget measures. Key financial measures include loan guarantees to firms and households, which correspond 0.8% of GDP, loan service deferrals by state-owned banks that correspond 1.5% of GDP, tax deferral for business that correspond 1.5% 5% of GDP, equity injections into public banks that correspond 0.5% of GDP, and short-term work schemes that correspond 0.5% of the GDP. Meanwhile, the government has imposed additional import tariffs on dozens of goods, including items used in the construction sector, some steel and iron products, spare parts used in the automobile sector, as well as a wide range of other goods such as dishwasher, freezer, jewelry, musical instruments, and sanitary products that could slow a rise in the current account deficit. When we start thinking about the options for tax policy reform in the aftermath of the crisis COVID-19, we will see three main focus areas for governments. First, new taxes will be introduced to meet the needs for new resources such as digital taxes, environmental taxes, wealth taxes, and the global excess profit tax. Second, we will see investment and production tax incentives for boosted economic growth. And lastly, we will see more strict enforcement and domestic as well as enforcement of domestic and as well as international laws. Considering the offshore wealth of Turkish taxpayers, as you can see from Gabriel Zucman's figures from 2017, one can rightly assume that international tax enforcement will be a high policy priority for Turkey in the aftermath of COVID-19 crisis. As a matter of fact, these numbers must be much more higher now. Since the military coup attempt in 2016, many Turkish people have transferred their wealth abroad. Let me remind you a little bit about the basic of the international taxation. Under Turkish income taxation, based on the universality principle also implemented in many domestic tax law systems, residence taxpayers are exposed to Turkish taxation on their worldwide income. This means taxpayer must inform the Turkish tax authority about domestic sources as well as foreign sourced income earned during the fiscal year. However, the capacity of the tax administration to enforce the worldwide income taxation depends on its ability to obtain cross-border tax information. Although the Turkish tax administration, like many others, is legally entitled to access such data, to do so requires the reach of the tax administration to extend beyond national borders. This may also be the case for non-resident taxpayers exposed to Turkish taxation limited to income from sources within Turkish boundaries, based on the principles of territoriality. Even if Turkey takes no account of the foreign income of non-resident taxpayers, the Turkish tax administration may need to receive information from the jurisdiction of residency about relevant legal condition in order to correctly implement tax law. Thus, transnational tax cooperation has the crucial role of empowering tax administrations to collect tax revenues in full and on time, thereby narrowing the tax gap created by international evasion and avoidance. Fortunately, cooperative international tax enforcement efforts have already led to the identification of more than 100 billion euros of additional tax revenues worldwide over the 2009 and 2019 period, according to the OECD. However, as I will show you today, there are impediments that Turkey has to take care of first to benefit from this kind of policy reform aftermath of the COVID-19 crisis. Double tax treaties have historically laid the legal basis for cross-border tax information exchange through articles pertaining to the exchange of information. In Turkey, there are around 19 double tax treaties in force. However, the adequacy of established transnational tax information exchange system in combating international income tax evasion and avoidance has been severely criticized, especially after the 2008 global economic crisis, widely seen as the catalyst for the recent progress on transparency and cross-border tax information exchange in the world. Turkey was among the countries most affected by the 2018 global economic crisis. Thus, it can be rightly assumed that at the London Summit on April 2, 2019, when the leaders of the G20 declared that the era of bank secrecy is over and underscored the importance of inclusive international tax cooperation, Turkey, a member of the G20, set cross-border tax transparency high on its political agenda. In this direction, recent moves to increase the robustness of the OECD article and commentary pertaining to exchange information has been reflected in the signing of new treaties, an alteration to some existing Turkish double tax treaties through protocols. Moreover, Turkey has signed 5 tax information exchange agreements since 2010, as well as the Multilateral Convention on Mutual Administrative Assistance on November 3, 2011, or shortly Multilateral Convention, instruments aiming to incorporate both tax haven jurisdiction and developing countries into transnational tax information networks. Nonetheless, Turkey has operationalized such agreements very slowly. There was an average interval of 4 years between the signing of tax information exchange agreements and their full ratification. Parliamentary ratification of the Multilateral Convention took place on May 3, 2017, with the Council of Ministers ratification accompanied by reservations and declarations made on October 30, 2017. Eventually, the agreement came into effect at international level as of July 1, 2018, almost 7 years after the initial signature. Then, Turkey ratified a multilateral competent authority agreement on December 31, 2019. Doing so activated exchange relationship for information on financial accounts, known in OECD terminology as Common Reporting Standard, or shortly CRS information, with 57 jurisdictions. However, Turkey has not fully met the domestic translation requirements for the exchange of CRS information. In order to translate financial account information collection and reporting obligation into domestic law for the purposes of the automatic exchange, the Turkish Parliament passed Law 761 of November 28, 2017, that amended Article 257 bis of the tax procedure law. Nonetheless, the amendment only introduced an empowering provision to the Minister of Finance to regulate the automatic reporting standard by issuing a regulation. Since then, there has been no published regulation. Considering that the OECD asked for the primary legislation to be included in the scope of obligation, i.e. due diligence and reporting requirements, the amended provision does not fulfill the prerequisite for translation. Furthermore, Turkey's approach to exchanging information on request has displayed important deficiencies. Even the European Union or the EU, by far Turkey's largest trading partner, has grey listed the country as a result of these deficiencies. Since December 2007, the EU has classified countries as black or gray in relation to the risk indicators of preferential regimes, zero or no corporate income tax, and transparency and exchange of information. The EU's executive body, the European Council, takes tax and non-tax countermeasures against blacklisted jurisdictions. It moves gray-listed jurisdictions to the blacklist if they fail to make sufficient progress in addressing the highlighted areas of risk. In all lists published today, Turkey has been gray-listed owing to deficiencies in relation to requests for exchange of information and in effective implementation of the automatic exchange of information. While the 2020 list notes some developments in the area of automatic exchange of information, as I mentioned earlier, it emphasizes that Turkey will be relegated to the blacklist in subsequent updates if it fails to make the required actions. Considering the economic ties between Turkey and the EU, the European Council's defensive measures against blacklisted jurisdictions, this would likely have important consequences for the Turkish economy. It is important to understand the reason for the Turkish government's lack of urgency in making its cross-border tax affairs more transparent. To this end, first, I will examine possible reasons for Turkey's apparent reluctance to enforce the exchange of tax information. Then I will analyze the ways in which cross-border tax transparency might raise in the Turkish political agenda. An official Ministry of Finance press release dated June 10, 2018 offers some clues about a possible rationale for the delay in the implementation of automatic exchange of information standard. The press release sought to alleviate the concerns of the millions of Turkish citizens residing in and receiving welfare payments from EU countries such as Germany. According to several statements from the Turkish-German community, many Turkish immigrants will be affected by activated exchange relationships on CRS information because their undeclared wealth and income from this wealth would disqualify them from welfare payments. For instance, Germany would both cut the social security support of those affected and seek to recover previous payments on which interest would be charged. Furthermore, the German tax administration would reassess the tax liabilities of these people and impose tax evasion penalties for undeclared income. While the Minister of Finance also stated that Turkey would finalize legal, administrative, and technical frameworks by the end of 2019, the implementation delays clearly aim to provide secrecy to Turkish immigrants. This approach is problematic in two aspects. First, it clearly undermines Turkish commitment to transnational tax cooperation. Second, it overlooks the fact that the automatic exchange of information standard help countries to narrow down the gap in their jurisdictions created by international tax evasion. In other words, the automatic exchange of information standard was created to divert revenues from private individuals and corporations to the treasuries of states. As a matter of fact, a number of well-publicized leaks of the tax data has identified the offshore holdings of wealthy Turkish residents, individual and corporate taxpayers, implicating various Turkish politicians and public officials. For example, they revealed links between offshore entities and the families or close friends of the Turkish presidents, prime minister, and the mayor of Istanbul based on the Panama and Paradise Papers. They illuminated an offshore tax avoidance schemes via Malta and Sweden that the Turkish president's son-in-law created in an attempt to repatriate his Dubai company's profit to Turkey tax-free, and the offshore wealth of the Turkish prime minister's family was estimated at least 140 million USD based on the Malta files. However, unlike many other countries, this leaked data has not spurred the Turkish government to prosecute taxpayers, sanction tax advisors, or make additional tax assessments. From the deficiencies determined earlier, it is also apparent that these leaks have not induced the expeditious enactment of new laws or stimulated further agreements to create greater cross-border tax transparency. Thus, I want to discuss how cross-border tax transparency may be promoted up the Turkish political agenda by considering a past tax scandal that attract policy attention and raised public awareness in Turkey. Before the recent wave of international tax scandals, Turkey became a party to a cross-border tax scandal that erupted in 2000. It revealed that several Turkish immigrants invested their savings in Turkey with the help of the German Dresdner Bank, but apparently didn't declare their interest revenues to the German tax authorities. The background to this story is as follows. In the 1960s, Turkey introduced a scheme to address the deteriorating external imbalance that it had endured for a number of years. This Dresdner Bank schemes was based on a money transfer agreement between Dresdner Bank and the Turkish Central Bank that permitted savings accounts to be opened at the Turkish Central Bank through the agency of Dresdner Bank. The latter collected private deposits of the Turkish citizens living abroad and forwarded them to the Turkish Central Bank in exchange for a commission. In the beginning of 1975, the scheme was expanded to any non-resident who wanted to benefit it. Since the Central Bank of Turkey offered higher interest rates than those available on the euro market, it attracted a high volume of savings. In 1999, the German tax auditors inspected a Turkish citizen resident in Germany and identified undeclared interest income from his holdings. The taxpayers then revealed the agreement between Turkish Central Bank and Dresdner Bank to the Frankfurt Public Prosecutor's Office. Thereupon, in 2000, the German tax auditors raided the liaison office of the Turkish Central Bank in Frankfurt and Berlin and the head office of the Dresdner Bank under a search warrant to determine account owners. Afterwards, the local tax offices started to send additional tax assessment and tax penalty notices to the related parties. This was also alarming since a large number of these taxpayers were welfare recipients, meaning they would also later be investigated for social security deception. This scandal was brought to the attention of the Turkish public via two channels, press and parliamentary oversight. Turkish newspapers first reported the raids to the liaison office of the Turkish Central Bank, highlighting the possibility of tax inspections against accounts holder from the bank. Later on, the European edition of a Turkish newspaper published in Frankfurt revealed the presence of 7,000 tax evasion investigation files at the Frankfurt Prosecution Office, and a deal between Darmstadt Tax Office and the Turkish Central Bank that supposedly would allow the total amount of associated tax fines to be collected from the bank. The Turkish Central Bank then sent a disclaimer to the newspaper denying the existence of any such deal. When parliamentary attention was drawn to the matter, an MP from the coalition of ruling parties submitted a written question to the presidency of Turkish Grand National Assembly to be referred to the Minister of the State on July 17, 2001. The presidency forwarded the question on September 25, 2001, and the minister responded to it on October 11, 2001. The response detailed the agreement between the Turkish Central Bank and the Dresdner Bank and strongly underlined that the responsibility to declare income rested on the taxpayer, and the Turkish Central Bank was not liable for the declared interest income of account holders. Neither the Turkish press nor parliamentarians took this scandal as a transparency and transnational tax cooperation issue. Apparently, the base origin of German tax revenue was not an issue of concerns for Turkey at that time. As a matter of fact, Turkey and Germany signed their first income tax treaty in 1975. That came into force as of December 13, 1989. In accordance with the treaty models, Article 25 of the treaty included an exchange of information provision. Thus, these responses neglected the fundamental obligation of exchange of information. Still, they informed the public about the Resner Bank scheme and how it was used by the Turkish government as a tool of foreign borrowing and by Turkish citizens resident abroad as a tool of tax evasion. In this regard, the past scandal showed the importance of press and parliamentary oversight in creating public awareness of tax-related issues. It also offers insight into the recent reluctance of the Turkish government to improve cross-border tax transparency and in turn, the ways in which transparency can rise in the Turkish public agenda, since the influence of both forums, i.e. press and parliamentary scrutiny, has declined in Turkey, particularly since 2013. Freedom of press is a constitutionally protected right in Turkey. Article 28 of the 1982 Constitution sets that the press is free and shall not be censored and requires the state to take the necessary measures to ensure freedom of the press and information. However, severe obstruction of press freedom has been noted with internet censorship, intimidation, attacks, and murders perpetrated against journalists, civil defamation cases, media pluralism, and ownership structures, among other examples. While some progress has occurred since 2019, Article 28 has been contravened on numerous occasions since corruption investigations were launched against the highest level of the government on December 17, 2013. Among other examples, Pelin Ünker, a journalist who reported on the Panama and Paradise paper in 2016 and 17, was sued by politicians and their close family members for defamation in the criminal and civil courts. In both cases, she was sentenced to imprisonment, but the prison sentences were overturned on appeal due to a statute of limitation. Nevertheless, she was ordered to pay compensation by civil courts. Pelin remains the first and the only journalist to investigate the recent international tax scandals inside Turkey. Meanwhile, the president has increased his power to the detriment of parliament as well as other government branches and state agencies. The 2007 constitutional amendments ended the parliamentary system of government that had existence for a long time and introduced a presidential form of government without strong checks and balances. In parallel, the number of parliamentary oversight tools decreased. The mechanism of oral questions with debate, parliamentary investigation, and parliamentary inquiry remain, but interpellation was removed from the means of parliamentary oversight. Although it was rarely used throughout parliamentary history, interpellation was the most powerful of these mechanisms, since it enabled parliament to vote the cabinet or its individual members out of office. Its loss is a noteworthy sign of the weakening of parliamentary authority, although the effectiveness of the remaining means of parliamentary oversight has also declined in recent years. For example, after the Panama Papers mentioned not name, but the number of offshore holdings of Turkish residents at that time, an MP from the opposition party referred a question to the Minister of Finance on April 5th, 2016 about what would be the government's response and whether the government would prosecute taxpayers or make additional tax assessments. The July 18, 2016 response to this was very vague and didn't invoke Turkey's tax tracing network as a means of receiving information. Moreover, when an offshore tax leak occurred domestically in 2017, a group of opposition parliamentary members also demanded a parliamentary investigation as another way of parliamentary oversight. However, it couldn't be initiated as a result of insufficient number of votes. Consequently, the lack of strong parliamentary oversight and restrictions on media freedom hinders the creation of domestic support for cross-border tax transparency in Turkey. This finding is particularly important considering that the OECD mainly focuses on governmental efforts to create transparency. Unfortunately, until we overcome these impediments, international tax enforcement efforts in the context of COVID-19 tax policies won't produce expected result in Turkey. Before COVID-19, Turkey experienced the 1994, 2000, 2001, 2008 economic crisis and the 1999 Marmara earthquakes in the recent era. Among the measures taken against this crisis, there were also tax measures. However, several tax measures were brought before the Turkish Constitutional Court with a cancellation request, and these requests were accepted alongside rejection. Claims of unconstitutionality will inevitably come to the agenda in case of COVID-19 tax lawmaking occurs without considering the legal priorities that appear in these rulings. In other words, constitutional problems may arise in the implementation of COVID-19 tax policies. For this reason, I also analyzed the Turkish Constitutional Court rulings regarding anti-crisis fiscal measures in my project and determined fiscal law priorities that must be taken into consideration while creating COVID-19 Turkish tax policies. When I look at whether there is a Turkish Constitutional Court decision related to international tax transparency reform in a time of crisis, I only see one case. After the 2008 economic crisis, Turkey introduced a temporary voluntary disclosure program by law number 5811 to take advantage of the momentum gained by the increased occurrence of whistleblower reporting and the growth in cross-border tax information resulting from increased transnational tax cooperation at that time. However, the law also incorporated domestic assets into the voluntary disclosure program. Nonetheless, the law required an additional tax assessment of 2% in the case of international asset disclosure and 5% in the case of domestic asset disclosure. The opposition party brought this different treatment before the Constitutional Court, claiming unconstitutionality based on discrimination. The court found that the different treatment constitutional, considering that the ability of enforcement of tax law to offshore wealth is much harder for the tax administration than to onshore wealth. And the court added that this different treatment was proportional and compatible with the legality principle. Thus, any attempt, any temporary voluntary disclosure program in the COVID-19 tax policy reform must take equality, proportionality, and legality principles into account. Just last week, Turkey introduced another voluntary disclosure program on November 11, 2020. I am not going to examine in details here, but I want to give an example to show that the government didn't consider the legal priorities for tax transparency reform that the Constitutional Court stated in its decision, which I mentioned previously. According to the new law number 7256, Article 21, the President of the Republic may extend the periods in this article up to 1 year, each time not exceeding 6 months from the end date. This is a breach of the legality principle. According to the legality principle, taxes are prescribed by law. This principle is reflected in Article 73, paragraph 3 of the 19 1982 Turkish Constitution, entitled Tax Duty as follows: taxes, fees, duties, and other such financial obligations shall be imposed, amended, and revoked by law. However, according to paragraph 4 of Article 73, the President may be empowered to amend the percentages of exemption, exceptions, and reduction of taxes, fees, duties, and other such financial levies within the minimum and maximum limits prescribed by law. This delegation of power has three distinct features, one of which is that the Parliament may authorize the President to determine only tax elements of rate, exemption, and reduction. The Parliament can't delegate power to the President regarding time. Thus, I expect a constitutional lawsuit soon. So that's it. Thank you for listening to me, and I would love to hear your comments and questions.
Thank you very much, Leyla. This is a very, let me just start by saying that this is a very interesting research that you're doing, and how courageous it is considering what's happening in Turkey in the political context. And you've provided us with not only with the legal analysis of the issue of transparency and tax avoidance and evasion, but also a political and contextualized analysis that is so relevant. One thing that is very clear from your research is this worry that you have with law and practice, not only what we call law in the books, right? So how we implement laws and how they're actually enforced or not enforced, and the problems that we face into translating something from the books, from the text into reality. So thank you very much. So we're gonna start with the questions, and I have 3 students that will have priority. But before that, as usual, we're gonna give you a round of applause virtually. Thank you, Leyla.